Are you tired of government overreach and eroded freedoms? At tac-us.org, we're fighting back. We're the Transparency Accountability Coalition, a non-profit defending your constitutional rights. No partisanship, just principle. From protecting free speech to demanding transparency, we're here for you. Visit tac-us.org to learn more and join the movement. tac-us.org, because your rights deserve a voice. Act now.
What's going on? It's Celiac here, and this video comes from Cammed Up Caveman. And if you don't know who this guy is, you need to go over there, subscribe to him, because he's dealing with some poopy stuff in some place I'm not going to talk about. But we're just going to hop into this. But so, like I said, Auditpalooza 2025 links, all the links will be in the description. If you are serious and you want to come to this, please email me. All right? That being said, let's go.
Was recording this city council meeting to thereafter post it on YouTube to get likes and subscribers and make money off of his YouTube channel. He was recording this city council meeting the entire time so he could post it on YouTube and get a reaction out of his subscribers. He actually has a lot of subscribers.
Hey everyone, as you just heard from Assistant State's Attorney Theresa Brown, it clearly frustrates the government when citizens speak out against corrupt and abusive officials and record themselves doing it, especially when those citizens share video evidence online, gaining clicks and views, and earning ad revenue doing exactly what mainstream media does.
Yeah, buddy!
I usually don't ask for money or expect help covering the cost of obtaining public records, body cam footage, 911 calls, or maintaining the equipment I use to document government overreach or report on what I witness in the community. I believe doing so could take away from the idea that I do this as a public service. That being said, I don't believe earning ad revenue from my content cheapens that purpose in any way. In this particular case, I've enabled channel memberships as a way for supporters to help offset those costs.
And I don't know exactly how much his memberships are. They could probably start as low as $1, maybe a couple dollars more. But if you want to help, his link to join his membership to see all the videos behind, whether it's $1 or $5, I don't know. Go over there and subscribe, because he's got some great video, but for some reason he just doesn't get half the traction. So please give him some support, because the Armed Fisherman said so. The link will be in the description. Make sure you put a friggin' comment saying the Armed Fisherman sent you, alright?
Members will get early access to select premium content. And yes, I know that will probably irritate certain government officials even more, which honestly makes it worth mentioning. The first members-only videos will cover my recent jury trial in Clearwater for the charge of disrupting an assembly at a Clearwater City Council meeting. If you'd like to support the channel, just look for the Join button next to my channel name and logo below. Once you click on it, a pop-up will appear. Click the Join button again and follow the instructions from there. I know some people get upset that others might want to help fund what I do. I find that a little amusing. But just to be clear, I do not profit from my YouTube channel.
All right, please. County Court in Pinellas County is now in session with the Honorable Brett Simmons, County Court Judge presiding. For all those coming before the court, please stay standing, raise your right hand, raise your card, and take the oath. Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please say I do.
All right, thank you. You can be seeing everybody. Let me start with Mr. Huffman first, as it's a trial, make sure we're good, and then Mr. Hunter is right there. Mr. Huffman, can you hear me?
Yes, sir.
All right, very good. So, Mr. Huffman here for trial with Ms. DeWitt. Let me start with the state. Is the state ready to proceed to trial?
Yes, sir.
Is the defense ready to proceed to trial?
Yes, Your Honor.
Anything before I say let's call the jurors kind of thing from the state?
We may need to readdress some of the motions in limine, Your Honor. It's been a while, and some of them I think may need to get readdressed in anticipation of what the testimony is going to look like today, if that's okay with Your Honor.
Well, that's testimony, not jury, right? So, Oh, yeah, fair enough. So, Mr. Goldenberg, in the future, he just said there may be some motions limited to be readdressed. Just make sure you're speaking in the microphone for Mr. Huffman. And I will say to the state also, and the defense, just beware that, I just say this from when I first started my career, that be careful of what you say into the microphone. I'm sure everything you say is proper and all that, but everything you say will be picked up by Mr. Huffman or anyone listening. So just any private conversation or amongst each other, just realize that it's going to, unless you hit mute, it'll be picked up. Not that Mr. Huffman shouldn't hear anything, but if it's, whatever strategy, then just realize whatever you say into the microphone will be heard by all.
Well, no fucking shit.
So, all right, so Deputy, I think we reserved 30 for that, so if we can get, or we talked about 30 yesterday, I should say. So, 10 o'clock, please. 10 o'clock. All right, so Mr. Huffman, you're free to move about the court house. If you leave the courtroom, I think you probably need to leave the headphones if you leave the courtroom, but just if there's anyone who's a potential juror, or you don't know them, don't even talk to them, okay? So just we're making sure that everyone's staying clear. Anything else from the defense I should ask before we call the jury up?
No, Your Honor.
Okay. All right, Mr. Huffman, we'll see you again. If you want a bottle of water or something, you can bring it in here. And we'll get this thing wrapped up in the not-too-distant future, okay?
Okay, is it okay to sit outside?
Well, yes-ish. I just said yes. Just is he allowed to go outside with the headphones, or does he have to leave them in here?
He has to leave them in the courtroom with us.
Got it. So yes, you can go out, just you can't bring the headphones with you, okay?
Okay.
All right. Oh, and then the last thing is, I had asked your attorney yesterday whether or not we want to address, I prefer to. I know that your shades are prescription, and that's fine. If you want me to say something to the jury in the sense of that those are prescription shades, that's why you're wearing shades.
And I'm sure all y'all were guessing why I was wearing glasses. Normally, I normally don't even have them on the top of my head. Sometimes I do, sometimes I don't. The only reason is that I'm trying to say, something. I really respect Cammed Up Caveman for doing the things he does. And I want you to go and support Cammed Up Caveman. Links are in the description, and let him know. The reason he wears glasses like that, I think he has, it's something about light and vision. That's why he wears glasses all the time. So I was just giving him a little support. That's the only reason. So let's get back to the video.
I'm not disputing that. That's fine. Are you okay with me saying that those are prescription shades, which is why you're wearing the glasses or something to those effect?
Yes, sir.
Okay. All right. Sounds good. Anything else, Mr. Huffman, question-wise or anything? No. Okay. All right. So there you go. The obvious, try to state the obvious, which is that you are not allowed to communicate with the jury in any way. You can't have any reactions, verbal or otherwise, or anything along those lines. And once you're there, you're stuck, kind of thing, while we're doing the jury selection process. So if there's an issue for you needing to go in and out, then you're stuck, just so you know, while this process. So, but if you want to, you can observe, okay? So the deputies will just let you know where you need to be for that. We're good, Mr. Huffman?
Yes, sir.
All right, sounds good. So defense's motion number 2 is to exclude any and all testimony or evidence regarding Mr. Huffman's potential social media activity, and we reserved on that because I think we're kind of figuring out what's going on. So, well, I guess we'll start with the state. Do you anticipate on trying to get in any social media activity, and if so, what?
Yes, Your Honor. First off, Mr. Huffman, can you hear me?
I can, yes, ma'am.
Okay, just wanted to make sure. So, first, Your Honor, I think, if I may, if I could bring up a fundamental issue of the case.
I'm all ears.
So, I jumped on this case recently, and I think the state and the defense are probably in agreement that a fundamental issue here is Mr. Huffman's right to the First Amendment.
And here we go.
And whether or not the speech that he gave and the conduct that, happened at the City Council meeting on February 15th, 2024 is protected by the First Amendment and, his freedom of expression.
My pussy hurts.
I would argue that that is a question of law that should be made to you, and it's your decision based off of the case law and just the precedent of First Amendment rights, whether or not his words are protected by the First Amendment, and that should have been something that would have been asserted in a motion to dismiss this case. I don't think that it is a question for the jury to decide whether his rights are protected by the First Amendment.
Yeah. I don't know if you heard that, but DJ, rewind that shit.
a question for the jury to decide whether his rights are protected by the First Amendment, and we anticipate that defense being asserted, and I think that that's an issue we should address outright right now.
Well, does that have to do with the social media activity, or no?
I think it's part of it, but...
Well, what is the social media activity?
So the social media activity is the defendant, Mr. Huffman, has a prominent YouTube channel called Caveman. On the date of offense, he was recording this incident and then subsequently posted it.
Oh, dude, what are you talking about, dude?
Try not to make any more.
Are we in recess?
Shut up, don't talk to me and I won't say nothing.
Are we in recess?
That's how it is.
Is that what you said? Fuck the police. You want to kick me out? Fuck the police and fuck the city council too. Suck my dick.
To YouTube, where it got many comments, many likes. He has thousands of subscribers, and what I would be trying to get into when interviewing Detective Lightfoot is that during his investigation of this case, he looked into the defendant. He found his social media page, and he saw that the defendant had posted this interaction on YouTube. Part of the jury instruction for this charge is that it has to be willfully or also maliciously. And part of it is the intent aspect of he was recording this city council meeting to thereafter post it on YouTube to get likes and subscribers and make money off of his YouTube channel. It goes into the intent aspect of why he was there to begin with, why he was recording, and he wasn't just recording the city council meeting to just record it. He knew that a disruption was going to occur. That's why he had his camera on.
I don't know. Leave your comment down below if you think that that's like one of the most bullshit arguments that they could have had. Cammed Up Caveman didn't know that there was going to be a disruption. They knew I was coming, and they knew I was mad. They knew I was serving them an intent to sue. Everybody knew about that. Even the council knew about I was going to come and serve them. And when I served them and I threw my jacket off, just to let you know, Mr. Unks, what he has in his hand, you've been served. Mr. Margulies, you are now served. Mrs. Call, there's going to be one for the city. You're served. Unfortunately, the tyrant, Gandy's not here, and there's one for him too.
That's your first warning, violation of Rule 15. You can either go out in the hallway and turn inside out. You can
Cohen versus California allows me to wear this shirt. Cohen versus California, the guy had.
Please remove Mr. Taylor from the meeting. Let's take a break.
Hi. This is no different. This is going to be a second.
Remove that gentleman also.
I know. I'm getting my stuff.
Meaning to just record it. He knew that a disruption was going to occur. That's why he had his camera on.
Well, what statement, or I follow what you're saying so far. What statement or posting or whatever? What do you anticipate that you're getting in evidentiary-wise to show that?
Just that the detective found that he had posted this video on social media.
Okay. So just that fact.
And that he has a social media called Cammed Up Caveman, which this video was posted to, and that it got likes. We wouldn't be asking about any of the other videos that he has on his page. We're not introducing any of those videos. It literally is just that during this investigation, part of what led him down the path of, sending this to us for this charge regarding this defendant is the video that he watched, which was on his YouTube.
All right. Ms. DeWitt, I'm sorry.
Yes, Your Honor. Not only is his social media activity completely irrelevant, but any discovery we receive from the state, it is not his social media posting, it's someone else. That's why you can see him in the video with a camera. It'd be literally impossible for that to be his recording, and it's not posted on his YouTube channel. Not just that, but there's been multiple opportunities to address this back in May in MILs, July 2nd during amended MILs. So I think it's absurd that we're addressing it the morning of trial when the only time it's mentioned in discovery is from a detective who wasn't there about some older woman speculating that they were recording for social media.
Are these Clearwater City Council, and again, for everyone who's paying attention at home, I don't even know what this case is about in terms of the facts of it, just the allegation of it, right? So I don't even know what the disturbing part is. I guess we'll all find out together, or I'll find out with everybody else. But does the Clearwater City Council record their meetings online? And they're available for everyone's nodding along, I guess.
They are.
Okay, so is the recording? I guess that's an interesting question. Well, what's the allegation? Let's go with that. So what's the allegation of the disturbance or the interrupting or disturbing a lawful assembly?
Factual basis. Do you want to go?
Sure,
Okay.
Your Honor. On or around February.
You don't have to be right on it, just close enough to it that Mr. Huffman can hear you.
On February 15, 2024, approximately 6:30 p.m., Your Honor, there was a city council meeting. During one of the final portions of the meeting, there was an interruption by a gentleman named Mr. Taylor, Michael Taylor.
Man, that's some bullshit. I didn't interrupt anything. I just took off a jacket that had some words on it, and they were the ones that kicked me out saying my shirt was a disrupted. So I didn't disrupt anything. I just said, hey, here's some paperwork. You're served. And then I took my jacket off, and then I got kicked out. I'm like, if that's the disturbance, oh my gosh, you gotta be kidding.
By a gentleman named Mr. Taylor, Michael Taylor. He incited the interruption, took his shirt off, started screaming obscenities, cursing at the city council, and then there were other voices in the audience that contributed to this, Your Honor. So Mr. Huffman was one of the loudest in the audience besides Mr. Taylor, and he screamed, fuck the police, fuck the city council, fuck the mayor, things of that nature. And then he was ultimately excused from the meeting. But the recess started with Mr. Taylor's disturbance, that initial disturbance. A handful of minutes later, Mr. Huffman jumps in, continues screaming, continues cursing at different members of the audience and at the city council, at law enforcement, and then he is ultimately excused. Okay.
So, okay, fair enough. So now let's go back to the social media part. So, you know what? So I'm just going to talk this out, and then we'll kind of go from there. So, Ms. Brown's right in the sense that they have to show that it's willful, have to be able to show it's willfully and maliciously interrupted, right? Okay, so that's fine. So the intent aspect is an aspect. So I guess that's a true statement. The social media aspect of it, so he's got we'll just call it YouTube page, whatever it is, right? I forget the name, but whatever. So do you know, is there any statements that he made on any comments or anything like that anticipate getting in or anything like that? Like any comments on anything anybody commented on? Or is that part of this or no?
No, Your Honor. And to Ms. DeWitt's point, we're not trying to even get the video that he posted in through the detective. I'm just trying to, it is a fact that he posted this video on his YouTube. I'm just trying to get through the detective that when he was investigating this, that is something that he found. And I think he was recording this city council meeting the entire time so he could post it on YouTube and get a reaction out of his subscribers. He actually has a lot of subscribers. And so I think that goes to this being intentional, it being willful. They knew the disruption was going to occur. It was pre-planned.
And just so that we get the friggin' skeletons out of the closet right now, none of them knew what was going to happen. The only thing that they knew was I was going there to serve them with an intent to sue. That's all they friggin' knew. So I don't know where they're coming up with this, because if that was the case, and they know who I am, I wasn't called as a witness. I wasn't called, nobody called me to go over there to either defend him or go against them. Nobody did that.
Well, that's a factual issue
right.
in terms of
but
that is our
argument.
So then, and I just want to fine tune as best I can, understanding it, because your argument is you want to say that he put the video, regardless if he recorded it. I suppose I don't think that really matters too much, on a YouTube page, and the detectives found that while investigating. And then you want to argue whatever intent that may be to the jury. Okay. So I don't think it's necessarily a discovery issue. I was trying to figure that out, Ms. DeWitt, also. Is there like any comments or likes or whatever you want to call it, right? As to that. So back to the motion limited then, to exclude any and all testimony or evidence relating to his, I'm sorry, that's not it. Any and all testimony potential social media activity. What I'm concerned about in part is saying, well, this is the purpose, like he's got a bunch of subscribers or he's got a bunch of followers or any of that. I think you're going to have an issue with that for not only authentication issues, but I think that's a little too far afield of that. If you want to say that they found he has a YouTube page and he put it on there and then you want to argue whatever from there, I think that part's okay, but anything else beyond that, it's not. But I'm all ears, Mr. Witt. So, again, we're not talking about we're talking about weight, not admissibility, right? So just admissibility of the detective saying he has a social media page. I found this posted on there. I think that's where it ends.
Sorry, I didn't mean to interrupt.
No, go ahead.
The detective learned he had a social media page through a statement of someone else. And I also it's not relevant to the crime charge. Him having a social media page has nothing to do with his action of disturbing an assembly. I don't understand how this is coming up again when towards the end of the report it mentions a video on his YouTube channel. There is nothing on his YouTube channel of this date that he recorded on his own.
Yeah, and that's fine. I mean, I agree with what you're saying in that regards. It's if it's limited to, and again, I'm not saying I agree with the state's argument also, right? I'm not saying that one way or the other. That's not for me to weigh in on. It's more of if they're saying that one of the ways that we anticipate on arguing willful and intentionally is that he has a YouTube page, he put this up, and that's it. We're nothing about the content of any other video, not about how many subscribers he has, not about how many likes he has on a video, not about how many comments he has on a video, just the fact that he put this up on a YouTube page. That is, I think that's fine to argue. And then, again, not to say that that is willful or malicious, but if that's what they want to argue, so be it, that's fine. But no content about anything else. And just to address what you said, Mr. Witt, about whether or not he recorded it or not, that's not necessarily the issue for my ruling purposes. It's more of saying whether or not they recorded or not, it's not what, if I'm understanding the state correctly, is not what is at issue, just that there was recording of it, and the state can say, all right, it was up there, and then they can argue that was willful, and then I'm sure you'll say it wasn't, whatever.
May I, going off that point,
sure.
They just said that he was at the meeting so he could post it on YouTube, so that's why I mentioned that.
Oh, I see what you're saying. That's a fair point. I mean, I guess there's something to be... fine-tuned in terms of what you say there. Like it's not that he recorded it up there, but there was a recording. I think that's a fair point. That there's a recording he put up there, unless it's him doing, whatever it was. Unless that's what the video is. I don't know.
Your Honor, actually, just to clarify, there's like 800 plus videos on Mr. Huffman's YouTube.
We're not here for those.
Right. I haven't seen all of them, of course, but from what I've gathered, there are 3 videos. One of them I can't find anymore, so it might not be posted. That's the one of his point of view. That's the one of his camera. That's the one of him recording. However, and I believe that was shared with defense in earlier discussion.
Are you putting in any videos in this case or not?
We are, but it's just going to be body worn, Your Honor. So we're not going to put his point of view on video.
Is there? You see Mr. Huffman on the body worn camera?
You can.
Can you see a camera on him?
Okay. He has a tripod. It's a big camera right in front of him.
Well, if you want to argue that, then.
And then there's also 2 other videos where he posts, like, to echo what defense is saying, it's not him recording, it's somebody else, because there was multiple people recording in the audience that day, but he posted it, like reposted, I guess, in small clips or smaller clips in 2 other videos that I know of. There may be more, but from my looking into the case, and then Detective Lightfoot did mention in his report that he looked into that, so that was shared with defense.
Well, I mean, but what evidence do you anticipate on putting in? What physical evidence, not testifying? What physical evidence do you anticipate on putting in the trial today?
All of it.
Well, what's all of it?
So we have the agenda rules.
Mind you, those agenda rules were changed well before all this ever happened. They changed them because they were angry at me. And then, I'm nobody's fucking boss. I can't tell people what to do, but some people will show up on their own accord.
What's all of it?
So we have the agenda rules, we have the meeting rules, We have a few photos of the placards that are posted outside of the entryway where it says like the rules of civility, the pledge of conduct, things like that. We have 2 officer body-worn cameras, and then we have 2 blown-up photos of Mr. Huffman. They're screenshots from the officer body-worn.
Okay. All right. So, again, I mean, I'm still kind of
And Your Honor, we
confused.
have the video, or one of them.
Well, are you putting it in or not? That's a bigger question.
No, but this is the video from his point of view on his social media.
Okay. So, well, if you're not putting it in, then...
Just saying, we do have it.
Okay.
And it's a correct meter.
All right. So what are we talking about then? Still, going back to the original point. If you want to argue that he's got a YouTube page, he put any recording of this up, and therefore it was intentional, or whatever you want to argue in terms of it was intent to, what's the word? Willfully and maliciously interrupted or disturbed an assembly of people. Okay, then I suppose the fact that he put that up there, you can make that argument, but I don't think that's beyond that. Anything else that you're talking about, unless you put in evidence, is not. We're kind of talking best evidence rule at that point now, which rarely does that arise, right? But there we have it. Anyway, Ms. DeWitt, anything I need to clarify for any of that?
Could you clarify exactly what they're allowed to get into?
Yeah.
So
Sure. He had a YouTube page.
Sorry, I just want to make sure it's incredibly clear.
Sure. He has a YouTube page. Again, I'm not making the argument. I'm just saying what I'm okay
Yes.
with it. That he has a YouTube page. He put it up. He put up a recording of a city council meeting, and he did that. Again, this is what argument I'm going to allow, right? And he did it for malicious and willful purposes. At least, again, I'm not saying that's the case. I'm saying that I'm allowing that as an argument, right? So.
Am I allowed to ask, just to be clear, what the name of his YouTube page is, or just that he has a YouTube page?
Not his YouTube page. Doesn't matter what the name of it is.
Okay.
Yeah.
I just don't understand, because in the discovery, the officer and the investigator, Detective Lightfoot, he does not go into detail about any video posted on his social media page. It literally just says that he has social media, so I'm unsure how that would be.
Well, you bring up an interesting point, whether or not they can authenticate that aspect of it as well. I guess we'll find out.
Okay.
Right? I mean, you're right. I mean, they still have to be able to support whatever they're asking, right? And if for some reason it comes in, then have it as a cross, right? But the fact that it was in the police report, I'm not finding it's a discovery issue in terms of that aspect. Anything else along those lines, it sounds like it probably could have been, but we're not getting into that part for those purposes. Okay, anything else before I'll give you a couple minutes to go over these jury forms, but anything else we need to discuss before I take a break? You talking about the First Amendment arguments?
Yes, and there's one more as well.
That won't come up during jury selection, right?
No.
Well, it shouldn't come up.
I was going to screen some of it past the veneer, Your Honor. Or maybe
What part?
it a little bit, like the First Amendment, if it was at play here, if it was going to be used as a defense.
Well, what were you going to anticipate on asking?
The veneer?
Yes.
I was going to just talk about briefly the First Amendment and the 250 years of our democracy, how important it is, obviously. And
well, it's 249. We're not there yet.
Sorry, almost. And then just the difference between maybe protected and unprotected, and some things like that. Maybe the fire in the movie theater example from back in the early 20th century.
Generally, that's fine. Okay. So, First Amendment arguments. Again, anything that's going to be. How about this? Well, that's fine generally fine for jury selection stuff, and then we'll. Anything that we have to hash out during the trial, we'll hash out during the trial. I mean, I tend to agree, just generally speaking, that what Ms. Brown said is that, the defense can argue that it wasn't willful, and I'm going on a limb here. I'm not going to make Ms. DeWitt's argument or Ms. Evans' argument for them. But I'm going on a limb here and saying it wasn't willful and malicious, right? Now, I guess question whether it's protected speech or not and all the other fun stuff, we're not there yet. But we'll address it if we address it. But yeah. But I generally agree. You can't say this is lawful speech because the First Amendment says that. You can say it wasn't willful and malicious because it's something. There's a distinction there, I suppose. Anything else I need to address before we bring the jury?
So you want us to address those issues you're just talking about after jury selection?
Correct.
Okay.
Correct.
Are you tired of government overreach and eroded freedoms? At tac-us.org, we're fighting back. We're the Transparency Accountability Coalition, a non-profit defending your constitutional rights. No partisanship, just principle. From protecting free speech to demanding transparency, we're here for you. Visit tac-us.org to learn more and join the movement. TACUS.org, because your rights deserve a voice. Act now.
And like I said, Auditpalooza 2025. Links are in the description box down below, the little diggity down below. If you are serious and you say, oh, I have $100, I'm ready to go, email me at Auditpalooza 2025. Put your phone number in there. I will call you back. It's not that I don't want to talk to you guys, girls, everybody. What I am saying is I have to call a lot of people. We're filling up 100, 150 people into this venue. And so every minute that I have is very important. So I want you to understand that. So if you're not serious about this, please, don't email. It's not that I don't want you to email me. Please don't email me about this event. Please. Because I've talked to quite a few people, and it's not that I didn't appreciate the talk, but it wasted a lot of time. Because when I was like, hey, just send the money here, and they were like, well, I'm not going. I just wanted to talk to you. It's not that I don't want to talk to you. If you want to talk to me or talk to any one of the auditors that are coming, just pay the $100. You're going to get food. You're going to get an entertainment. You're going to get a band. You're going to get a grab bag. And you're going to get a meet and greet. And you're going to get all this stuff for multiple hours. And you'll have multiple hours to friggin' have this conversation instead of over a phone. So if you're serious about this, please email me at Auditpalooza. Links are in the description, all that good stuff. It is what it is. And don't forget, hit that like, share, and that subscribe button. And leave a comment down below, and I'm going to get out of here. Soliaker, deuces.